Recording in progress.
Iku Iluna, please rise. Aohea o ko e ko ka aha, I nahe, kuliana I mua o kea aha ho o kolo kolo ki I ke hano hano o ka moko aina o Hawaii. E nai mai, e malio mai, I lohi I ka leo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu, please be seated.
Please call the case.
Case number SCRQ-24-0000602 in the matter of the petition for coordination of Maui fire cases, arguing for the individual action plaintiffs, liaison counsel Jesse Creed, also appearing as liaison counsel Cynthia Wong, arguing for the defendants, Jinder Anders, pro hoc vice, also appearing as Nicholas Fram, pro hoc vice, arguing for the amicus curiae Consolidated class plaintiffs, Terrence Revere, also appearing is Kyle Smith, arguing for the appellees non-party subrogating insurers, Hyundai Marine and Fire Insurance Company, and the Dentist Insurance Company, Adam Romney, pro hoc vice, also appearing is Norman Leslie, arguments on the merits.
All right, good morning, aloha everyone. Today's proceeding is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. And I'd like to welcome our substitute justice, Judge Kevin Morcone. Thank you for sitting with us today, Judge Morcone. Counsel, are you all ready to proceed today? Yeah. All right. We have allocated 45 minutes for each side, as well as 10 minutes to the consolidated class plaintiffs. Just to confirm, Mr. Creed, you'll have 19 minutes. We'll give you a warning at 19 minutes in with 2 minutes to go in that period of time, followed by Mr. Anders with 18 minutes. Oh, pardon me, Ms. Anders with 18 minutes, a 2-minute warning when that time is about to expire. And each of you have reserved 4 minutes for rebuttal. Is that your understanding?
Yes.
All right. Mr. Revere will follow with 10 minutes. We'll give him a 2-minute warning before the end of his time. No rebuttal from Mr. Revere. Is that correct? Yeah, all right. And Mr. Romney, you'll have 45 minutes. We'll give you a warning with 10 minutes to go, correct? All right. We have a lot of folks arguing today. And at this point, let's begin with Mr. Creed.
Good morning, Chief Justice and members of the court. May it please the court. This reserve question appeal, requested sua sponte by the circuit court, will determine whether the roughly $4 billion settlement for the Maui fire victims survives. The legal premise of that $4 billion settlement, on which the plaintiffs and the defendants as parties to that agreement relied, is based on principles of Hawaii law established by Yukamoto and the statutes it interprets. That principle is that Hawaii law comprehensively regulates the recovery by insurance companies from their premium-paying policyholders who settle third-party claims. Because of this comprehensive framework established by the legislature, the insurance companies cannot attempt to circumvent the remedies selected by the legislature and thwart their policyholder settlement, like HMSA tried to do in Yukamoto. On August 8, 2023, the worst wildfire in Hawaii history ravaged the historic town of Lahaina, destroying thousands of homes, businesses, and social centers, claiming the lives of approximately 102 people, and traumatizing thousands of families. Shortly thereafter, hundreds of victims filed suit in the Second Circuit seeking compensation for both their tangible and intangible losses, from the destruction of their homes to the loss of loved ones and emotional distress from harrowing evacuations. The subrogating insurers look at this case as though each of those policyholders lost a home and suffered only economic quantifiable damages. But the equities of the losses at issue here are so much greater. The policyholders not only lost their home and the economic expense associated with it, they lost their schools and their workplaces, their churches and places of worship. They lost their playgrounds and community centers. They lost 102 of their neighbors and close friends. They have been displaced and dispersed throughout other islands and the mainland. They lost the core of the fabric of their community, and they need every penny to restitch the fabric and bring the community back together. I know myself, as I just lost my home, my childhood home, my kids' schools, and my place of worship in the Palisades fire. And people, when that happens, miss their community and they want to rebuild. But everybody faces a different financial challenge, and that financial challenge can be unbearable. The subrogating insurers seek full, unlimited reimbursement of the $2.3 billion they were obligated to pay to their premium-paying policyholders. But every penny they take outside of the rules, the substantive rules of 663-10, is one less penny that goes back to rebuilding Lahaina. Some victims, of course, received their insurance recoveries. And on August 2nd, 2024, after extensive mediations in which the insurers equally participated, the plaintiffs and the defendants entered into the term sheet. Everybody wanted to settle except the insurers. And contrary to what the insurers seek to portray before this court, they do not have a problem with the amount of the global settlement, which is nearly double the total value of all their claims. They frame this dispute as though it's a dispute between the insurers and the defendants, but that's not the reality. This is a dispute between the insurers and their premium-paying policyholders. The insurers want a bigger piece of the pie, And they want the leverage they can exploit through a direct action outside of 663-10. And that's what this dispute is about.
Mr. Creed, the question one from the circuit court, and this is very some technical legal issues, but I want to be sure that we understand the import if we were to answer that question. Yes. So it's talking about one of our recent cases, Yukamoto versus Tawarahara, and which addressed some of these issues about subrogation in the health insurance context. And the question is, to what extent does that ruling, should it extend to property insurers? And this is all about the statute HRS 66310, and whether that would bar these independent subrogation actions. What's your analysis of the applicability of that case to the property insurance context?
Those statutes, as interpreted by Yukamoto, do extend to property insurers because there's nothing in the text, and the subrogating insurers have identified nothing in the text to indicate that property insurers are excluded from application of those statutes and the interpretation in Yukamoto. In fact, the legislature has decided to exclude certain carriers, and those exclusions apply to auto carriers and workers' compensation carriers.
Are those the only entities or collateral sources that have subrogation rights?
Those entities would have property insurers have equitable subrogation rights. We're not disputing that. But those subrogation rights have to yield to the statutes as enacted by the legislature and as interpreted by this court. And that's the question presented here. In Yukamoto, the court was able to sidestep that question because HMSA was seeking to assert equitable subrogation rights. And the court was able to sidestep that question by saying that HMSA did not have equitable subrogation rights. It had contractual subrogation rights only. And therefore, the court need not address the viability of State Farm after the enactment of those statutes.
Your position is that we have a comprehensive scope, how are we, and statutory premise, then how are we why are we then also injecting equitable principles into this analysis?
The equitable principles would apply, I think, in two fronts. First, the question is, do those statutes abrogate the equitable principles? And I think the answer there is yes. But then when the circuit court on remand, so if the answer to the first question is yes, the court need not reach the second question. The third question does still remain relevant as an equitable principle. And the reason is, on remand, when the circuit court were to evaluate the validity and amount of each lien, the circuit court is looking for direction from this court about how the made whole rule would apply as part of the standards. So obviously there's the rule that Yukamoto established related to the non-duplication of recovery. If there's an award to the plaintiff and that award duplicates any proceeds received by the carrier, then the carrier would be entitled to it, except unless the policyholder had not been made whole. So the duplication is not exactly parallel to made whole, and the circuit court at the trial court level.
It just seems that you're suggesting that we should evaluate things simply based on the statutory scheme, but then you want to tack back into equitable subrogation and have that re-enter the mix when it suits you. Explain, what's up?
Well, I think it is consistent. The statute does abrogate to the extent that it creates a remedy and a procedure through 663-10 that attaches to the claim. But there's still the question of what standard needs to be applied when the court does evaluate the validity of the lien. And that validity question, which is in the statute itself, 663-10, brings in the questions about made whole, and because if made whole applies, then there would be no valid lien. That's our position, the plaintiff's position.
And if it doesn't apply, what would the analysis be?
What
would this look like if we answered question one yes, but held that the statute is a comprehensive scheme which doesn't leave room for the made whole doctrine to apply, what would happen then? What would it look like?
So in that case, it would look like the analysis in Yukamoto, which is that the court will evaluate whether the award to the plaintiff duplicates any recovery by the plaintiff as to the insurance companies. And the insurance companies, just like HMSA did in Yukamoto, would be entitled to discovery tools at their disposal to evaluate that question. And the practicality is that the analysis is not very difficult. So most of these will consensually resolve. That's our view.
Mr. Creed, I have a question with regards to when a claimant, a victim, settles with a tortfeasor with a general damages only release. What impact does that have? Like in Yukamoto, HMSA, I believe, would not allow any recovery because it was a general damage, or not because, but that was part of the circumstances. That's of very significant importance, I think, because it affects perhaps whether the subrogating insurers are able to, in fact, seek any reimbursement under the statutes. So I'd like to understand that. So you've just said they still would be entitled to discovery to determine duplication. Is that beyond, regardless of whether there is a general damages only release?
Well, I think the release would be part of the evidence, yes. So I think as courts, including in Yukamoto, and plaintiffs settle their cases throughout the circuit courts of Hawaii, include general damage releases, general damage only releases, and that typically, usually will bar the insurer from a recovery under 663-10.
General damages typically are for pain and suffering, physical injuries, things like that, not reconstruction of a home, losing property. So if somebody, a settlement needs to be in good faith, doesn't it?
Yes, Your Honor, and I think the discovery portion will give them the tools to evaluate whether this particular recovery was truly general damages, as the plaintiff and the defendant's release may state, which is not the case here, by the way, Your Honor. Here, there is, I know that the subrogating insurers have now inserted the settlement agreement into the record as part of their motion. And if you look at that, there is clear language about how the awards to the plaintiffs will not take into account insurance recovery. It'll be insurance agnostic, meaning that when the award is made to the plaintiff, they're not, the administrators are not going to, the claims administrators are not going to evaluate how much insurance proceeds that person made, which is, again, evidence that this was not a collusive settlement. They would be entitled under 663-10. They may be entitled under 663-10.
I don't want to get too far into the details of this case because the record is very slim before us. We're asked to answer 3 legal questions. That's what's before this court only. And so I just want to make sure I understand your reading of how these 2 statutes would apply to any property and casualty insurer. Recognizing that this is a very, very significant case, we also need to understand that this decision is going to apply to all property and casualty insurers going forward.
Yes. So again, I think that if you had a case where there was a general damages only release, the discovery tools available to the carrier, whether it's a medical or a property insurer, would enable them to evaluate whether that truly is the case. Just like in Yukamoto, there was indication and evidence of how much the total damages were for that plaintiff.
Right.
And obviously in that plaintiff, the plaintiff was not compensated for all their general damages, and therefore the compensation, it was a good faith general damages release in that case. So I think the insurers will be entitled to that kind of discovery. I want to be clear, I think it's important to clear up one thing, which is that the term sheet does not extinguish, destroy, or eliminate any rights of the subrogating insurers. The term sheet does nothing to alter whatever rights they may have to recover under Hawaii law. The statutes change that, and that the statutes and Yukamoto are the premise of the term sheet itself. The
So the
plaintiffs.
answer to question 2 would be no. they're not prejudiced. Is that what you're arguing? in
Yes.
essence there?
The argument on, if the court reaches yes on question 1, then the court need not reach question 2.
Or answer it no.
Or answer it no. Yes.
Under your point of view.
Yes,
And
Your Honor.
obviously, the subrogating insurers take a different point of view.
Yes.
Well, tell us this, what would make whole add to the analysis that you just set forth? So if, and I also want to understand, are you talking about the made whole doctrine being applied in addition to the provisions of the statute, or how would that work if we were to apply it?
So if the court were to answer question number 1, yes, and then question number 3, yes, then at the trial court level, after these awards are made to each of the plaintiffs, the insurers would be entitled to, well, the trial court shall determine the validity of the lien. And as part of that analysis, the trial court would evaluate both the question, does this award duplicate the special damages? And also the question, does the total recovery to this plaintiff make that plaintiff whole for all their losses, not just insurable losses?
How would the made whole doctrine work in a settlement situation?
Well, I think in a settlement situation, the make whole doctrine still works because you look at the amount, again, in this case, when the settlement will be agnostic to insurance recovery, the amount awarded to the plaintiff will be for their total losses, irrespective of insurance recovery. And so the trial court will conduct hearings like the Rhymes hearings is what we're suggesting. The plaintiffs are suggesting there's a body of law in Wisconsin involving evidentiary hearings where the trial court will take evidence on the total losses associated with that plaintiff.
Doesn't, as Justice Spinoza has indicated, we're asked to answer 3 questions which could apply in future cases. In tort cases, there's often comparative negligence. And I'm wondering, how would the make whole doctrine work in that type of situation where you have a settlement that factors in liability issues? And are you saying then that despite potential comparative negligence, the plaintiff would be able to recover the entirety of the general damages to which they might be entitled to?
Your Honor, I believe in that situation, the answer is they would be entitled because the dispute now is not between the plaintiff and the defendant, but the insurer who's legally obligated under the law to compensate the plaintiff. And so as between those two parties, the equities would dictate that the insured needs to be fully compensated for all losses before the insurer can recover anything. And that's the plaintiff's position.
You know, Morant's workers' comp case said no made whole doctrine. State Farm talked about it. The conclusion had nothing to do with the made whole doctrine. This court has never adopted the made whole doctrine. Is that correct?
I think, yes, Your Honor, the court has not formally adopted it. It's alluded to it, yes.
And has any court anywhere ever adopted the made whole doctrine in the context of a mass torts litigation?
I'm not, the answer is I am not aware of a case, but I don't think that's relevant. I think that the mass tort context makes it, it's just another claim. I mean, that's all this is.
It seems like the mass tort contract does make it relevant because if you're talking about the 1982 Wisconsin case and the Rhymes hearing, the courts would be clogged up with Rhymes hearing till the end of time. I mean, Rhymes was almost single plaintiff type of case and it was workable. How is the made whole doctrine workable in a mass tort situation?
I did get my yellow light, but I'd like to respond to this question. As has been discussed with the trial court here is a complex designated case under Rule 12 of the Circuit Court rules. And that gives the trial court the power to appoint special masters. And that's the procedure that the trial court and the parties have discussed with respect to resolving these very issues.
So maybe the courts aren't going to be clogged up forever, but maybe that process wouldn't it?
I think ultimately a lot of those will be settled consensually because I think the analysis will be fairly straightforward for the vast majority of the claims. Thank you. Thank you, Your Honor.
All right. Ms. Anders, your argument.
Chief Justice Rechtenwald, may it please the court. I'm Ginger Anders, arguing on behalf of the defendants today. This court should hold that the insurer's exclusive remedy is to assert liens against their policyholders in the context of the global settlement, and that the insurers may not bring direct subrogation actions against the defendants. That conclusion is compelled by established Hawaii law, most notably Yukamoto, in which this court definitively construed Section 431.13 and 663.10 to be comprehensive and exclusive. It said, if I could just quote at page 296, that, quote, the legislature limited reimbursement and subrogation for all insurance companies in Section 431.13, and it described Section 663.10 and 431.13 as providing the, quote, sole right to reimbursement and subrogation to recoup benefits paid from a settlement in a tort action. That conclusion controls this case because Yukamoto has authoritatively construed the statutes, it has construed the lien provisions as exclusive, and there is no textual basis in the statutes to distinguish the health insurer at issue in Yukamoto from the property insurers at issue here.
Ms. Anders, would you mind lowering your microphone a little bit more? Thank you very much.
Is that better? So if I could just address a couple of the points that were just made, I do think that Yukamoto has been the law of Hawaii since 2017, so the legislature is presumed to be aware of it. And as I said, this court construed these statutes to be comprehensive and exclusive for all insurers, and I don't think that there's a way to distinguish the health insurers that were at issue there. And I know that the insurers here try to say, well, maybe the statute applies only to health insurers, and Yukamoto applied only to health insurers, but that doesn't work because the text definitively forecloses it. So 431.13 applies to all insurers in the business of insurance, except for categories that are expressly exempted, as Mr. Creed mentioned. Neither of those is property insurers. Section 663.10 applies to all collateral sources, including health insurers, which means it applies well beyond health insurers. So that argument doesn't work. And I would just note that when we say that 663.10 applies, what we are saying is that because the statute itself says that it channels insurer claims into the lien procedure when there has been a judgment or settlement. So for property insurers who do have equitable subrogation rights, if there hasn't been a judgment or settlement, they still have those rights. They can proceed directly against a tortfeasor. But under the text of 663.10, if there has been a judgment or settlement, that is the lien procedure is the exclusive remedy as Yukamoto has construed that statute.
Ms. Sanders, the subrogating insurers point extensively to the State Farm versus Pacific Rental case. So I'd like you to address how that fits into the whole picture in light of your argument under the statutes. And that case, just for clarity, that really dealt with subrogation outside of statutory framework, correct?
That's correct, and that's because State Farm was decided so long ago. It was 1999, and so the version of 663.10 that applied at that time was very, very different, so it actually did not apply to the situation in State Farm. So there was no issue under 663.10, and so in 2000, the legislature broadened these statutes considerably. So what it did was it enacted 431.13 for the first time, and as this court said in Yukamoto, that made clear that this system was comprehensive and exclusive. And the other thing that the legislature did was it broadened 663.10 so that it applies even when there is no pending civil action. So that changed the situation that would have been in place at the time of State Farm because there was no.
663-10 existed when State Farm was decided. It was the other statute that was adopted after State Farm.
663-10 did exist, but it didn't apply to State Farm because it was narrower than it is today. So at the time of State Farm,
How was it narrower?
So 663.10 at the time applied only if there was a pending civil action. So that was the only situation in which the insurer would be channeled into the lien procedure. In State Farm itself, the civil action had been dismissed, so 663-10 didn't apply. And then in 2000, what the legislature did was it enacted 431.13 to comprehensively limit subrogation rights, and it also broadened 663-10 so that it covers even when it applies, even when there isn't a pending civil action. So I think those changes in the law, I think, really narrowed the effect of State Farm.
So the comprehensive view that I'm taking from your argument is that now that the statutes, both statutes have been adopted, if there is a tort suit filed, then 66310 would apply to address an insurer's reimbursement rights. If 66310 does not apply, there's not a tort suit filed, then other subrogation rights may apply. Is that correct?
That's correct. I would tweak it slightly to say
Sure.
that 663-10 channels into the lien procedure if there's been a judgment or settlement
Right.
in that tort action.
Right.
But yes, it is comprehensive, which is exactly what this court said in Yukamoto. So now if there's any tort action, then this statute applies.
And there's one part of 663-10 that allows somebody to petition the court if there isn't a pending action, right? To
That's correct.
address their reimbursement, for an insurer to address reimbursement rights?
That's correct.
Okay.
Yes.
I just wanted to go back to your comments about State Farm. If I understood you, you said there was no civil action pending in State Farm because it had been dismissed
I believe that's
during
right.
the litigation process?
So the
The
litigation.
trial court had dismissed the claim, right?
Right, so the litigation between, the litigation that led to the settlement no longer was pending because it had been dismissed, so the settlement had
Wasn't
occurred.
that
but
exactly
there
the
was
issue on appeal? I mean, you're saying the statute doesn't apply because there's no civil action pending, but the exact issue on appeal is whether the dismissal of the civil action was proper under the statute.
Well,
It seems like a circular argument, but help me out.
So I think the way it would have worked is that the insurer would have had to come in and assert and deal with 663-10 before the dismissal had occurred, before the dismissal that was under the appeal. That's my understanding of it, and so it didn't apply because there had already been a dismissal of the claim that had from the insured that had led to the settlement that had given rise to the release. So that was in the past. And so that's why 663-10
Is that like a
didn't
waiver
apply.
argument? I'm still not following. I mean, it seems to me like it's a little bit glib way of getting around State Farm. That's kind of how it's coming across. You know, like, well, there's no pending action because the trial court dismissed the action, and the whole issue is whether the action should have been dismissed or not. So that seems like kind of a quick way around it. I guess I'm wondering, do we need to overrule State Farm or what? And are you trying to avoid us having to do that, or do you think we need to?
So I don't think you need to overrule State Farm at all. So I think even if Your Honor doesn't agree with the fact that the 663-10 applied only to pending actions at that time, still think there are a couple things going on in State Farm that are very different. The first is that nobody raised an argument under 663-10, so it wasn't presented. And then the second thing is that in 2000, the legislature did enact 431.13, and in Yukamoto, this court said that made clear. What the court said was the legislature limited reimbursement and subrogation for all insurance companies in 431.13. So in 2000, that's where you have the legislature coming in and making this policy judgment that this should truly be a comprehensive procedure. So if there had been doubts before then, there were no doubts after 2000. So I think as a result of...
I think we understand the amendments after State Farm, and Yukamoto came after that. But I sort of want to follow up on the Chief Justice's comment. It seems like you're crashing directly into State Farm. I mean, and you suggested, we don't have to, overrule it or reverse it in any way, but it does seem that you're asking us to overrule it in the context of a property and casualty insurance, aren't you?
So I want to be very clear. I think State Farm still has considerable continuing force, and that continuing force is where 663-10 doesn't apply. So in any situation where there hasn't been a settlement or judgment, the insurer is still entitled to proceed in direct subrogation against the tortfeasor.
Okay, but similar to the questions I was asking Mr. Krebs, so your position is that equitable subrogation comes into the mix, even though you're arguing about the comprehensive scope of 663.10 and 431.
So it's comprehensive where it applies, yes. So I would say that because 663-10's text says that this is the procedure that applies when there's been a judgment or settlement, it's comprehensive in that scenario. Where that doesn't apply, so the legislature hasn't completely occupied the field, so where that doesn't apply, you still have State Farm establishing that property insurers have equitable subrogation rights, and they can go directly against a defendant in that situation. So I think that's how the system shakes out. Here, of course, we have a settlement. And I guess I wanted to make one point about the sort of policy judgment that the legislature made in 431.13. So I think when the legislature was considering adding health insurers to the statute, it heard testimony from the insurers that it would make subrogation more difficult to include them in the statute. But nonetheless, the legislature decided to enact this, and what it said when it did, it decided to enact 431 and include health insurers in the system. And what it said was, we are doing that because we are more concerned that the insurers, by insisting on subrogation, are going to be preventing insureds from reaching their preferred settlements. So what Yukimoto described that testimony and said that the insurers were claiming a disproportionate amount of the settlements. They were making it difficult to settle quickly, and they were delaying payments to claimants. That is exactly the concern here. So I think we are squarely within the purpose of these statutes. The plaintiffs have decided that that the settlement is the best possible resolution of these unprecedented lawsuits for them. And I think it's clear why that is. This is a situation in which litigation is simply not a reasonable way of resolving these lawsuits and compensating the plaintiffs' devastating losses in an amount of time that would be acceptable to them. It will take years or decades to litigate these cases to judgment, and recovery would be uncertain at the end, given the factual and legal complexities, the defenses, the number of claims that would have to be tried. So from the plaintiff's perspective, there has to be a settlement. And from the defendant's perspective, that settlement has to be global. And that's because when you have a situation like this with thousands of claims and cross claims, and where the potential liability is so massive, you cannot agree to pay billions of dollars without being sure that you are resolving all of the claims at once.
The subrogating insurers argue that there's been no real determination as to whether the settlement amount of $4 billion in fact is the maximum amount that could be paid by the defendants. Now, I know it was, I understand, according that it was the proposal of the mediators. I understand the subrogating insurers were part of those conversations, but would you agree that no court has ever evaluated whether $4 billion is an adequate amount? And if so, is that something that would happen? If not, pardon me, is that something that would happen on remand?
So it's true that no court has determined whether that amount is the most that anyone can pay or anything like that. But I don't think it's something that matters here legally. So certainly
Wait,
within
it matters on the made whole doctrine, doesn't it?
So I think that under the made whole doctrine, if we're talking about going into the lien procedure and figuring out who's been whether a plaintiff has been made whole, I'm not sure it matters, because I think you would be looking primarily at whether the plaintiff himself has been made whole based on
Well,
everything.
don't you need a
limiting
limiting fund to get into the made whole?
I think traditionally, yes, you do need a limited fund to get to made whole. But I think courts have also applied made whole when the insurer is seeking reimbursement against the insured, so that you have a situation where the insurer's recovery is going to come directly out of the insured. And so I understand that to be what Mr. Creed is conceptualizing here. But I think for purposes of the settlement overall, and whether it should be permitted to go forward, I don't think it matters. So for one thing, I think that the insurers are getting everything that they're entitled to under Hawaii law. I think the parties structured this settlement after looking at Hawaii law and Yukimoto and deciding that this is what the insurers were entitled to under the law. So that's why it looks the way it does.
What if the insurers argue that the overall amount isn't enough, and the plaintiffs and defendants settled for too little, and therefore it's not a good faith settlement from their point of view, and their lien rights are being impeded? Is that a conversation that the circuit court should entertain on remand, or not? And if not, why not?
So I think that I guess the way I would put it is that it's not relevant here for purposes of permitting the settlement to go forward. The mediator did find that this was the most that the defendants could reasonably be expected to pay under the circumstances after looking at financial condition and litigation outlook. And I think that determination was incredibly well-founded and also in the public interest. And if I could explain that, when you look at who the defendants are, right, we're talking about, for instance, the state of Hawaii. Its payments are coming out of public funds. And so any payment it makes is affecting what it can pay for public services, affecting how the services it gives to the citizens of Hawaii. Kamehameha Schools is a charitable trust for the benefit of Hawaiian children. And for Hawaiian Electric has always said that it is far preferable and in the public interest to resolve this case without resorting to bankruptcy, because there is a significant public interest in avoiding bankruptcy, given the significant regulation that the state exercises over the company, and also the harm that bankruptcy would impose going forward.
Can I shift gears a little bit on and focusing on 431? You know, say the policy holder gets their full policy limits. I mean, the insurer satisfies its contractual obligations. And, you know, how under the statute are they refusing or limiting coverage to any individual because the individual may have a third-party claim for recovery of damages?
So I don't think they are violating 431.13, but I think the way that I understand the relationship between those two statutes is that 431.13 says comprehensively in any tort action, an insurer always has to pay benefits first, regardless of any claim for damages. In a tort action, it has to pay damages first. So we assume it does that, and once it does that, the proviso then says there is one avenue to recoup those benefits paid, and that one avenue is pursuant to 663-10.
I guess sort of, I mean, do you need an unfair act?
So no, I think the statute is saying it would be an unfair act not to pay, but if you pay, you can recover your benefits in one way. So if you comply with the enacting clause of 431.13 and you go ahead and pay benefits, then the insurer can recoup those benefits in one avenue. And I think it's the combination of that sort of comprehensive rule.
It almost just seems that you're suggesting that just by virtue of them asserting their subrogation rights, that's somehow an unfair act, or that takes them within your comprehensive scope. Just the fact that they're just asserting, you know, the rights that they've always had, rights that they say go all the way back to the Kingdom of Hawaii.
And I think that's what Yukamoto said, essentially, that when an insurer in a tort action asserts a subrogation right, we are within 431.13 because the statute is comprehensive, right? So Yukamoto said that this limits reimbursement and subrogation for all companies, that it's comprehensive and the sole right. So I think the way it works is that it establishes the obligation of the insurer to pay comprehensively in any tort action. It has to pay benefits first. And so when it complies with that, as these insurers did, when it complies with that, the legislature then wanted to say, you can recoup those benefits that you paid in one way if the insured has received a judgment or settlement. So if they go out and sue the defendant, then you can get those benefits back, but you can only do it in this one way.
And what's your response? I heard Mr. Creed's response. If there's not even any civil action, there's no settlement, there's no judgment, is it back to equitable subrogation?
So I think then these statutory, in the abstract, if then these statutory provisions don't apply and the background equitable subrogation right does apply, and the insurer can go directly after the defendant. In the context of this settlement, if there's no claim, the insurers will still be able to make a claim against the settlement fund. In essence, they will step into the shoes of the insured. That's how it will work.
I want to come back to my prior question. On remand, will the subrogating insurers be able to challenge the settlement on the grounds that their lien rights have been unduly limited by the decision to settle for $4 billion as opposed to 5 or 6 or some other number?
So I don't think so. And if I could just make a couple of quick points about that. So I think the insurer's position here essentially is that the defendant should exhaust their assets, and the settlement is not reasonable unless they do that. And I think that has a lot of problems to it. There would never be any settlement if that were the rule. And as I said before, I think
those are the kind of arguments that a court couldn't hear and make a reasonable judgment on. Should the court in this case do that, or is it off the table?
So I think there is one safety valve in the 663-10 procedure, and that is that the court has discretion to determine the lien amount. And so
that's what I've been referring to. I'm sorry, it wasn't clear. That's exactly what I'm referring to. As part of that inquiry, can the insurers say, this is not a fair settlement, our lien rights have been unduly restricted because the pot is only $4 billion. Should have been more.
So this is to be worked out by the parties on remands. I don't want to get ahead of myself here, but I guess what I would say is that in the abstract, it seems to me that the statute would allow the court to look at the plaintiff's conduct and decide appropriately what it thinks the amount should be. And I would say that that is very similar to what occurs in allocation proceedings in the Medicaid and Medicare liens. So when you have you have damages and Medicaid wants to get back the money that it's paid, courts do engage in allocation, and they do look at how much, how the money should be split up to be fair. So it is possible there could be something like that.
I guess we've run a little bit over your allotted time. If anything to wrap up before we get to Mr. Revere?
Reserved for rebuttal.
All right, very well, thank you.
May it please the court, Terry Revere for the Consolidated Class Plaintiffs. I did have prepared remarks, but I respect and completely understand these questions because they're questions that all of us are struggling with, and several nails are being hit on the head here. Really what this boils down to is we've got, our view, 4 competing policies. We want victims to be made whole, for sure. We don't want them to get double recoveries. We want people to be able to settle their claims. And when appropriate, which is the key here, I think, for this case, we want to respect lien rights. I think the problem that the insurers are saying here is that they've got this right from God that, well, we get subrogation rights. Well, there's a ticket to get into that show, and that ticket, according to 2 Hawaii cases and cases all over the mainland, is first things first, you have to make sure the insured is made whole. That is cited. There's a good law review article that the court cited in the Yukimoto case called the Made Whole Doctrine. And to show how confusing this is, it's called Unraveling the Enigma Wrapped in the Mystery of Insurance Subrogation, 70 Missouri Law Review 723. And it's, so courts all across the country, frankly, are making a lot of confusion about this. They call legal equitable, they call it conventional, they mean contractual, so it's all over the place. But those 4 principles of we want to make people whole, we don't want plaintiffs to get a double recovery, we want plaintiffs and defendants to be able to settle their cases, those are sort of the guiding principles here.
Mr. Revere, could I just ask, maybe for way of context, who are your clients? Who do you anticipate they will be? What are the nature of their claims? How many folks are there? How are they going to be notified of their opportunity to participate if we answer the questions in the manner that has been suggested by your side?
Sure. So in order for this settlement to ever work, it needs a class. There's nobody doubts that. The short answer is going to be the class is going to be made up with whoever Judge Cahill decides in that class approval process, but we are representing, we have a wrongful death claimant. We have people that have suffered property losses, people that have suffered business losses, personal injury. So it's going to, we haven't gone through the Rule 23 process that we would normally, and we will do. And a lot of these questions about what's fair, et cetera, will be resolved in that class process because it has to, because that's how Rule 23 works. I think the important thing, these 2 Hawaii cases, one is the AIG versus Rutledge case, and one is the State Farm case. And I understand, and it's frustrating to me as a plaintiff's attorney to Justice Eden's comment, like, did we actually formally pronounce we accept the made whole doctrine? I don't think we have, but it's in every state. It's not like it's something new under the sun or something crazy or radical. And it has been cited in these, in different cases by the Hawaii court. And both the State Farm case and the AIG case say the same thing, that the amount paid by the insurer must result in the insured being made whole. The general rule is that the subrogated insurer is entitled to no subrogation or reduced subrogation if the result of full subrogation would be cause the insured to be less than fully compensated for the loss, although some cases hold to the contrary. So, and the AIG case says that as well. So this assumption that they just launch into subrogation is not true. The ticket to get into that movie is you've got to make sure your policyholders are made whole first, and there's no doubt about that. And being made whole.
Is that an inquiry that's case by case or in the aggregate?
I believe it is. I think the only, and I appreciate as a former law clerk here, the amounts of briefs that you folks have had to go through is enormous. One of the things once I got to the end of the pile was, we're not even arguing about that. We are saying on a case by case basis, you, the insurers, need to show that, okay, Mrs. Jones was fully compensated, then go ahead and assert your claims. But they haven't done that. What they decided to do is, oh, we're going to run over to Wahoo, file a case in front of Judge Ochiai, and try to grab the money and prevent these victims from getting their money. That ain't right. So the
Somewhere in the briefing, there was a notion that there's been $12 billion in damages, only $4 billion paid, so therefore made whole doctrine applies. That's a aggregate assessment. That's not what you're arguing for. You're arguing in each case, each person in your class is going to have to establish that, or actually the insurer would have to establish.
The insurer, yeah, the burden's on them. That's right, Chief Justice. And I think the other thing is that's really important, and I think we've hit upon it, and Justice Ganoza and Justice McKenna are definitely hitting on this, is there is a process. I think what makes sense is you go to 663 in a case like this where a claim has been asserted, and then you make your argument. So if I have a shack in a corporation, the shack, I don't live in it, I don't extract any business income, it burns to the ground. And then the insurer pays me the $50,000, whatever it takes to rebuild the shack. If I then, in bad faith, said, oh, my corporation's feelings are hurt, so I want to get some more money from the tortfeasor and give the insurer nothing, well, that is the type of process that happens in a 663-10 hearing. And I know that, remarkably, myself included, I'm guilty, but on these things that the court is struggling with or questioning is, we do have something similar, and it's called a good faith settlement law, where sometimes people say, you know, and they'll make all these same arguments. Oh, you should have made whatever, the manufacturer pay more, they got lots of money. Well, there's defendants in here that money, charity money, all these other things. That's all true. And a lot of these defendants, their lawyers get paid too. A lot of them, like the telecommunication companies, say, we ain't tortfeasors at all. So the fact that you're getting something is, you know, something to be noted, and it's not, does anyone feel it's adequate? No. Have I ever in the history of my career been happy with a mediator's proposal? No. Nobody was happy with it, but everybody but the insurers thought we have to move on in life.
Are you suggesting we use the good faith settlement principle for like multi-defendant cases where one defendant is settles, the others are still in, the Troyer test, I think?
Yeah.
So it could be used, or it could be a model.
It could be a model for Judge Cahill or any circuit court judge going through this. Hey, was this in good faith? There's liability issues in this case. There are entities that will go bankrupt. And I don't think this is Hawaii. We do not have to drive every single defendant into the turf, to use a football analogy. We make reasonable settlements. We don't want our county to go bankrupt. We don't want to take huge amounts from the biggest charity in the state. We are trying to do something that is reasonable. I see my time is up. Can I just make one last point?
Absolutely.
All right, thank you.
Wrap up.
One thing that I think is important is that the insurers argue that, this can all be modified via contract.
And that's just a warning for you. You do have about 2 more minutes,
Oh,
actually, a little less.
thank you.
Sorry about that.
Thank you. Oh, I
No.
feel so much better.
The more we talk about it, the less time you have, though, so I'll let you go.
Thank you. It's not red. Sorry about that. One thing that's important, and we cite the cases towards the end of our brief, it is not enough for any insurer to go, well, we've got a contract, so we get to ignore the made whole doctrine. That is not true. There's the Chandler case that we cite and other cases that say, if you want to avoid the made whole doctrine, which is part of the common law forever, basically, you need to have clear and specific language in that contract that says something along the lines of the made whole doctrine does not apply.
How do you determine made whole for general damages? I
Right.
can see it for special damages, but the lien only really
Yeah.
pertains to special damages.
Sure. And so if we have good judges at the circuit court level, and they have to do that every day. They have to do that when we do good faith settlement in a, one side not settling for whatever reason context all the time. Like, oh, it says general damages, and there have been, games that people played, but it's up to the judges in that Troyer versus Adams context to go through and say, is this legit or not? Did Terry Corp really suffer, emotional damages? Of course not. So that's bogus. Give the insurer their money. But that's the type of process that needs to go through on a case-by-case basis. In general, I think obviously the third question should be answered yes, and I have nothing further. Thank you.
All right. Thank you, Mr. Revere. Mr. Romney.
Thank you, Your Honors. We appreciate the opportunity to come and argue this before you today. The first thing I want to bring up is that ultimately I think that the settling parties are kind of operating on a false premise here. We're not trying to block any settlement of IP claims, truly. We welcome settlement of this case. We would like there to be a settlement that helps everybody, resolves all claims.
Would you mind lowering the microphone too?
We're speaking,
Thank you.
to it a bit more. It's
Sure. The global settlement is something that we would prefer to have happen. We would like a global settlement to occur. So to be as clear as possible about this, our position is that the settling parties, the class action plaintiffs, the individual plaintiffs, they can settle for any amount they want. They can settle for the full $4.037 billion that they've announced. They can take every penny that is on offer and leave us to fight for whatever is left, hypothetically. What they can't do, and this is where we're drawing that line, is settle our claims as part of that deal. And that's sort of a basic fundamental premise of fairness, is that they just aren't their claims to sell. Really, the case law in Hawaii has been very clear for a long time, and even just is actually a year ago yesterday that the Park v. City and County of Honolulu case was announced by this court, which reaffirms something that's always been true, which is that subrogation rights accrue.
Well, I think
upon that
Park
date.
was a well-authored opinion. And I would say, and probably that table would say, that that was a workers' comp case. The individual in that case kind of blew it. So therefore, you're stepping into the shoes there. So I think you might be a little bit astray by analogizing this case or trying to use Park for this case.
Oh, I understand that, but not every subrogation, because the reason the workers' comp matters is because there's a specific workers' comp statute. And I understand that, but I agree that Park was well written. And part of the reason that I agree it was well written is because of the way in which it describes the general principles of subrogation. And one of the things that it says is that subrogating insurers they slip into comfortable shoes. They don't have shoddy shoes, and they have real rights. They don't have rights that can be dismissed and negotiated away by other people. And that's ultimately what the State Farm case reaffirmed here, in Hawaii. And that's what it was reaffirmed again and restated in the Yukamoto opinion, is that those are subrogations claims, and they cannot be when the defendant tortfeasor knows and they have actual or constructive knowledge.
Do you think that the legislature has the power to enter into a comprehensive scheme that abrogates common law?
I don't have an opinion as to whether or not the legislature has the power to do that. In part because I'm not a scholar of the legislative authority. But what I will say is that in this case they have not done that, and I think that that's consistent with Yukamoto. And Yukamoto's reasoning really turns on this fundamental conceptual distinction between fire, property, casualty, subrogation rights, and lines of personal insurance, which were medical insurance policies, as was explained there. And in particular, I thought what was most useful, the Yukamoto decision cites to a footnote, I believe it's footnote 5, which is actually a horn book, and it's a law review article maybe, but it's describing the difference between them conceptually. And what it describes is there's a difference in the res, that in a personal insurance policy, when you're insuring a person's well-being, their health, that person is the one that the insurance company takes responsibility for. That's the res of the policy. And by contrast, in our kinds of insurance policies, property policies, the res is the the res is inherently more limited. It's not all ways in which a person could be injured. It is just that property itself. And that,
The properties are homes.
no, and that is true. But the properties being homes was accounted for when we made these distinctions in State Farm, right? And that is part of the Yukamoto analysis. Part of the reason that in Yukamoto, it reaffirmed and said, that the Yukamoto reasoning has this very specific pathway, right? It says that the HMSA claims they have both equitable subrogation rights and contractual subrogation rights. And it systematically explains why there are no equitable subrogation rights in the context of that different res, that personal insurance policy.
I'm going to ask you again to speak into the microphone.
Yes, sorry.
Sorry.
I feel like I'm yelling when I'm so close. So,
I'm sorry.
yes, and so the Yukamoto reasoning breaks out that distinction in the res in terms of what it is that is being insured. And it ultimately uses that to determine that the abrogation of equitable subrogation rights in the context of personal insurance was consistent with longstanding Hawaii doctrine, specifically the Rutledge case and the Sol case, in which it was determined that those rights were necessarily limited because of that conceptual difference. Now, so in Yukamoto, it then had the obverse statement that it was preserving to keep that consistent with State Farm, that in the context of fire, property, casualty insurance, that's our claim, that equitable subrogation still exists. And to be honest with you, you all are asking questions earlier about their position seems to run directly into State Farm, and they're trying to figure out a way to not say that it overrules State Farm. It is irreconcilable. Your instincts on that are correct. To be honest, if you asked me to write my fantasy precedent that I could quote to you, I couldn't do better than that State Farm line. It's so clearly on point to this case. And there isn't a way to sort of extend the Yukamoto decision or its way of
What about the fact
problem.
that the statute 431 changed? So that's the key from the plaintiffs and defendants side. The statute that was being interpreted, or the statutes that were being interpreted in State Farm, changed in their view, a very significant way. What's your answer to that?
Well, I don't think they changed in a very significant way. I believe that it was Justice Ganoza, indicated, for example, that 663 was extant at the time that State Farm was decided. And more importantly, it did not, those statute changes had occurred already at the time Yukamoto was decided. And so when Yukamoto cites State Farm approvingly, and specifically for the holding that we are suggesting is still relevant, that was done in the context of the new statutory language. If this
You would
court
agree
believed-
that that would be dicta since Yukamoto was not a property insurance case?
I don't agree that it would be dicta. And the reason I don't agree it would be dicta is because it was used to evaluate whether equitable subrogation rights still exist in total. And what the Yukamoto decision in my reading says is they still exist for property and subrogation, but they don't exist in this case for HMSA. And so that's the reason that the decision can't truly be extended, because it would have to undo that entire reasoning. It would have to say that actually the legislature.
So are you
eliminated all.
suggesting that the silence in Yukamoto comports with your position? Is that what you're basing that on?
What do you mean by the silence?
Well, the fact that it didn't say anything really. I mean, it talked about contracts, not equitable subrogation.
Well, I disagree that it didn't talk about equitable subrogation. I don't think it is silent. It's over many pages in which it describes the history of.
Okay,
yeah.
okay, it didn't talk about it, but the holding was not premised on it.
The holding, well, the ultimate holding that the contractual subrogation. Is that what you mean?
Yes.
Yeah, but so that obviously related to, in Yukamoto, the health insurance, those personal lines of insurance. And one of the reasons that you can tell that is in the Yukamoto decision, there's various portions of 663 that are underlined and emphasized by the court and then discussed. And then and then the court in Yukamoto made various conclusions based upon those underlying provisions, and specifically went back and read and cited the standing committee reports from the Hawaii legislature. Now, those committee reports, we actually gave you snippets of them, the relevant pieces for how the legislature intended to modify the law when it enacted 663. And it's really unequivocal. And our readings of those committee reports are consistent with Yukamoto's recitations of what the legislature intended. It says consistently that the legislature intended to change the comprehensive structure as it related to health insurance policies. There's no mention of equitable property subrogation at all.
Wasn't it all about health insurance when in 2000 and 2001? That was all about HMSA, at least in 2001, right? The legislature was focused on what was happening with HMSA when the statute was further amended in 2002. And that's why it would seem like that was a focus then of Yukamoto. But did it exclude the possibility that the plaintiffs and defendants are arguing for here, which is that the principles there could be extended?
Well, so I believe that you're referring to the third committee report that we cited, which was the 2002 committee report. And so I would answer that in that the other two ones that we cited that were before the issue with HMSA came up in 2000 and 2001 also specifically mentioned health insurance and health insurers' obligations. And second of all, the third committee report that you are describing in 2002 described the legislature's intent in the past tense. It says that when we enacted this, we intended to. It does not say that they are trying to fix something about it. They're describing their intent at the time of enactment. So I believe that is.
Could I ask you this? What is it about the lien process that's prejudicial to your clients? In other words, if you could explain that, because I know one thing I noticed, it's more subject to equitable defenses, but I'm not sure exactly what that means. So what is it about that procedure exactly that you view as less as prejudicial as opposed to subrogation claims?
Sure. So first of all, State Farm itself defined what prejudicing the insurer's subrogation right would mean. And in State Farm, what this court said is that it would mean that if you had the right to bring a suit and then you no longer had the right to bring a suit. And based on that term, that is obviously what is happening to our claims if our rights to sue the tortfeasor, which were protected under State Farm, are eliminated, and instead we are forced to bring a different cause of action entirely, not subrogation, reimbursement, and we're forced to sue our own insureds. That is obviously distasteful. It's a thing that triggers these made whole considerations. This is not an equitable doctrine that even if Hawaii had adopted it, that the defendants could ever bring. And that is ultimately the mechanism of the purported global settlement, is to release our rights to pursue subrogation claims, channel them, which is actually the words that I believe that in the defendant's answering brief, instead redirect them, channel them into a different claim against a different party, and then to reduce them to essentially zero.
You don't really have to file a separate lawsuit against an insured. Though 663-10, the process is for insurers to file claims of liens in the lawsuits.
Well, I think that's a distinction without a difference here. And what I mean by that is that still puts us adverse to our insureds, which is not the position that we are in now.
That happens in Hawaii. There are claims for liens filed by insurance companies under 663-10.
Well, what I would say to that is that there are actually no reported cases in Hawaii applying 663-10 to a property and casualty subrogation claim. It does happen in Hawaii in the context of personal insurance, but there is no record and no party has cited any record indicating that has happened in a context like ours. Furthermore, I think that there was some suspicion that I heard, maybe it was from Justice Edens, about the difficulties of a
Can you
lien
define
process.
personal insurance?
Sure.
What you mean by that?
Sure. This is when I was referencing the res of the policy, this is described in Yukamoto. The personal insurance relates to things that are the well-being of the actual insurance. So it's health insurance, life insurance. And that's something and those are fundamentally different than insuring.
Well, property insurance, like property homeowners insurance, would be personal to the person, right?
Well, I think that we're changing the definition of the word personal, and that is obviously.
So this is like a technical term that you're using, like an insurance term.
Yes, it's a technical term, but it is the technical distinction that was used in Yukamoto, and it's not just in Yukamoto. I believe that we cited from a 1902 case, with Liverpool and London, in which the territorial court said, health insurance and property insurance is not like life insurance. That's what it said. It is fundamentally about a different kind of thing. And ultimately, one of the questions that was asked earlier was about the situations in which we have paid the full amount of our policies, in which we have, this is a thing that is in the briefs themselves. They acknowledge that in many instances, we as the subrogating insurers have paid the full amount. We've paid the policy limits. And so one of the ways in which we're prejudiced, and this relates to your question, is that by channeling this into a situation where we are now forced to sue our insureds, it's not a true subrogation action.
In what sense are you suing your insurers? And I think I want to follow up on Justice McKenna's point, because as I understand the statute, it seems like it's a hearing, it's a procedure in front of the court. You assert this claim, but it's not like you're going to haul your insurers into court for a jury trial. You're there in front of the court.
Okay,
As a claimant. I mean, there's all kinds of folks assert liens in cases. That's not an unusual situation, as Justice McKenna said. So,
sure, and it's possible. I'm using suit a little too colloquially. What I really mean is to seek recovery as against our insureds, and that's ultimately that is not a situation that we are in now.
But
That's
if
a
you're
situation.
asserting a subrogation claim that's going to result in the settlement not going forward, or that's going to result in a smaller amount going to your insured, in what way is that not sort of achieving the same evil that you're describing in this context?
Well, so that's where I want to push back on that. And when I was saying earlier that they can settle for any amount that they want. They can settle for exactly 4.037 and ask us to go get whatever we can out of the rest. We are serious about that. We are not. We don't believe that the outcome of this court sort of rejecting the settlement agreement is invalid. Is that there is no settlement and the victims will not get anything. What it means is that there will be a different settlement. It means that there will be a different settlement that is actually global, in which all parties really have an opportunity to negotiate what that means. And ultimately, I think what you're seeing here is this is not really a contest about whether we have rights versus the insureds have rights. It's whether the defendants and the insureds can get together and tell us this is the amount that you are allowed, and anything else means that we are going to fight you, and we are going to say that you are taking money away from our pockets. That's not a real settlement.
I don't remember the record saying they said you get X amount. I thought there was a process that has to take place, which is you file a claim for a lien or assert a claim for a lien, and then the court is supposed to decide whether to recognize that claim or not. So it's not like, at least as far as I know, I'm not aware of anywhere in the record that says here's a fixed number that the insurers are going to get.
So yes, so what I'm speaking about is in the context of a global settlement, which is what I believe the defendant said that they would like to see. So the options here were we accept a number that they determined for us and said that this is the amount that they think it's fair for us to have, or we have to go through this whole process with you. And what we are saying is that the independent right to subrogation
Wait,
is more important.
isn't it the circuit court decides? I mean, I don't know exactly what's happened in terms of the settlement, but isn't it up to the circuit court to decide what amount? Because your lien is your claim would only be for special damages, and I understand that there's a lot of general damages plaintiffs here too who lost their lives, and that would not be a subject of a lien. So isn't it for the circuit court to decide what portion is going to be allocated to what type of special damages, depending on what the global proportion would be?
Well, I believe that we're speculating there. And the reason is because, as Justice Evans pointed out, there has never been a case reported in Hawaii applying the made-whole doctrine in terms of that allocation between the insurer and the insured. So we don't have any precedent for a procedure for that. It would have to be
Putting aside the made-whole doctrine, because as I indicated earlier, it seems that in tort-type cases, I mean, how do you even determine if a person has been made whole in terms of general damages?
You can't. And that's actually, I know that we talked about Rhymes hearings in the context of made whole earlier, and this is actually a point that's been made on a case called Mueller, which we cited in our briefs in Wisconsin, in which it described a number of instances in which that sort of the hearing that you are describing, the circuit court would make that decision, is inappropriate. And that's actually instructive. One of the things that the Mueller court in Wisconsin relied upon was actually reasoning very similar to Yukamoto and about the special and general damages. You know, it said that when you have a property and insurance policy, like was the subject of Mueller, it's difficult to figure out, to weigh that against softer damages, you know, your pain and suffering. There was a loss of consortium claim in Mueller. And the reason that the Wisconsin court there said, no, it doesn't apply, that made whole Rhymes proceeding doesn't apply, is precisely for the reason you're identifying, is that it's sort of a neither fish nor fowl. These two things don't make sense to try to be weighed against one another. There's no way to make a coherent rule that can be followed. And that actually is important because I know that the plaintiffs and the settling parties are suggesting that you all follow or adopt Wisconsin's version of the made whole rule. but I think it's important to look at what that actually is. Wisconsin isn't really a model for the made whole rule. The reason that people say it's a leading state is just due to the number of cases rather than the quality of cases or the adoption of Wisconsin decisions in other places. The Rhymes hearing proceeding has not been adopted anywhere. And in Wisconsin, in the 35 years or so, the last 35 years, there's been 17 Supreme Court with modifications to their made whole rule. And the reason is that this is ultimately a cautionary tale, is once you start trying to weigh equities for every single situation, it ends up back here over and over again. It's not possible to make a single one-size-fits-all rule. I believe it was Justice Ginoza, maybe, who asked a question about contributory negligence, in the context. To me, it was McKenna. I'm sorry. It's been a long day. Who asked a question about contributory negligence in the context of the made whole rule. That issue has come up in Wisconsin 3 separate times, and it was actually done, I think it's 2016 and 2017. They have different rules on 2 consecutive years. The answer is it's just impossible as a practical matter to administer at the circuit court level. It will be back
seems
here.
to me that the made whole doctrine would only really make sense possibly in a special damages situation. I just don't see how it can even apply in general damages. You'd have to have a trial to determine what the appropriate general damages are.
Absolutely. Absolutely. That's accurate. And ultimately, I think that the other reason, and we've talked about the limited fund issues that relate to the made whole doctrine, and you are correct that that's really a threshold issue, is that you never get.
Thank you for saying I'm correct. That might not always be the case. But let me ask, let's shift back to 66310.
Sure.
I mean, there's no limiting language there. The phrase included is used, that generally means part of a group. You have any civil action in tort. You have sort of a definition of lien. You got the title of the statute. You got Yukamoto and its comprehensive scope language. I mean, how does the text of 66310, Yukamoto's position, how does that all relate to what you're arguing to us, that it doesn't extend beyond health insurers?
Well, sure. So Yukamoto, I think, makes it clear that it applied 66310 as a way to eliminate the contractual subrogation rights, and that distinction between equitable subrogation rights and contractual subrogation rights was a key point underpinning Yukamoto. So it's easy to say that the 66310 in its comprehensive scope relates only to a contractual assertion in the context of health insurance as dictated by
So you're basically saying there's really no conflict. I mean, because I mean, it's almost, the common law is defeated by statute, right? So I guess, is it your position that it's just sort of outside the statute?
I think that my position is that in Yukamoto, it was very clear that the entire discussion of equitable subrogation rights existed in that case to show that it was outside of the statute. 66310 abrogated a specific class of contractual subrogation rights only. And interestingly, Yukamoto did not talk about contractual subrogation rights in the context of property and casualty insurance at all, because it wasn't at issue. It's not mentioned once.
And I have one other question, again, shifting a little bit gears, but it's a question I posed to Ms. Anders relating to the 431 and, the idea that you're limiting coverage or you're refusing coverage, and what is your position whether these issues are really implicated by that when you've paid out, or in many cases have paid out, full policy limits?
So yeah, our position is that it is obviously not implicated. And the reason is actually Rutledge, the AIG versus Rutledge is instructive on this point. So the statute, which we called the Unfair Act statute because the number is so long, the statute describes it prohibits refusing to provide coverage or limiting coverage. And Rutledge described that as a reduction in coverage. That was prohibited is reducing the amount of money that was given. And that's actually where it's important. Here is in the cases where we have given out the full policy limits, there's nothing else to give. We're trying to pursue our subrogation cause of action against the defendant. There's no effort to take any money back. So there is no reduction, in the sense of there being an elimination or a limitation of coverage. We are not reducing any coverage that could be given. For everyone who has the full amount of their policy limits, that's it. And ultimately, I think that's one of the reasons that if you look at the Rutledge decision itself, it describes that it's important to have subrogation rights because in the absence of that, if there isn't a stop, then what happens is that we don't become the casualty insurer anymore for our insureds. We become the liability insurer for the defendants. If we have to give up something else, give up our ability to recover in subrogation to get back what was paid, that ultimately is for the benefit of the defendants themselves. It's not for the benefit of our insureds.
Mr. Romney, on that point, CJ tried to ask you earlier, how is the lien process prejudicial to insurers? And you talked about the process, but I think ultimately the question goes to the recovery. So if we answer question 1, no, and Yukamoto does not extend to property and casualty insurers, and insurers are entitled to pursue subrogation rights, sue the tortfeasors, it's not like you're going to get the entirety of what you've paid out. You still have to go through a process there to determine duplication of payments and things like that. Isn't that true? In other words, how is that situation in terms of recovery and perhaps process different than the lien process that the legislature has adopted under the 2 statutes that we're talking about?
Well, I don't think that we would have to just describe duplication of payments. Ultimately, this is one of the things that's interesting about property subrogation is that our damages really are liquidated. I mean, the damages portion of a trial is here are all the checks we wrote.
So let me ask you this. In the context of a real situation, say, not this case, any tort matter, a tortfeasor has paid out, let's just take a round number, $100,000. 50,000 of it is for pain and suffering. The other 50,000 is for property damage. You've paid out, for whatever reason, let's just say you've paid out 75,000 under your insurance policy. Are you saying you're entitled to go in and simply get that $75,000 back?
I would dispute the characterization of simply go in and get the $75,000
Under
back.
subrogation, equitable subrogation rights, do you believe that you would be entitled to reimbursement, not reimbursement, entitled to subrogation of the entire $75,000?
Yes, and I think that is consistent with Hawaii law, that our rights of subrogation accrue, in the amount of and at the time of payment. And so it would not be, our suit would be independent of that $100,000 settlement. And if the defendant wants to say, that's actually a double payment because of money that we've already paid and we should get a credit, that's a damages issue for them to bring. But it doesn't prejudice our right to assert a $75,000 claim because we did, under your example, actually pay $75,000.
Subrogation is an equitable remedy, right? I mean, if you're talking about under State Farm, it's an equitable right. So if a victim has received $50,000 because of their pain and suffering, as opposed to the damage to their property, you're saying that you're able to encroach in and recover on the general damages part and the pain and suffering part beyond the property damages part.
Well, no, I think that's where the difference is that we're not talking about that $100,000 settlement with the insured at all. We are only talking about bringing a $75,000, in your example, action against the defendant directly, and it has nothing to do with that $100,000 settlement. And I think that, and that's an important distinction here, and actually State Farm addresses this directly because when the conflict is between the subrogating insurer's interest and the defendants, the tortfeasors, the people who actually cause the damage, what State Farm says is where the insurer's subrogation right clashes with the tortfeasor's contractual release right, the insurer's subrogation right will prevail. And that, I think, is the actual conflict involved. It's nothing about going in and encroaching, or there is no conflict in our view. We aren't trying to take any money away or reduce what an individual plaintiff would recover.
So I hear what you're saying. So basically then the tortfeasor who has now paid out $100,000 to the victim is now going to have to pay an additional $75,000 for the funds that the property insurer has paid out.
Well,
the
so
entirety of it.
this is where there's some difficulty with the hypothetical, and I don't mean, I know never fight the hypo is the watchword in law school, but it could be, for example, that the additional $50,000 in the individual plaintiff suit is because that's on top of the insured damages, like those uninsured
Speak
damages
into the mic, I'm
claims.
sorry. I'm so sorry to.
It's okay. I speak
just, if
quickly
we can't
too.
hear you, that's.
And could you slow down a little bit
I
so
would
we can
love to.
understand what you're saying?
Yes.
I
So
think the ultimate question for me is like, isn't there a process even in an equitable subrogation lawsuit that would look at the equities of the situation in terms of how much insurer could get back based on what the tortfeasor has already paid? So again, going back to the Chief Justice's question, what is the prejudice to the lien process, which allows the insurers to do that through discovery, as we've talked about, and to look at whether there has been a good faith settlement versus a subrogation action separate and apart from that statutory lien process?
sure. And I will default again to the way in which prejudice was defined in State Farm. You know, where in State Farm it said if you could have brought one claim and now you can't, that's prejudiced. That's the definition of it. And here, we would have the right to pursue the tortfeasor, and we no longer have that right. That is prejudicial. Now, the process.
The legislature has provided another right or a different process, and that's their intent. I guess what I was trying to understand is maybe this goes to us understanding what the intent of the legislature was or how we could properly assess it. What is it about the lien process that's inadequate? Maybe I'll use that word from the point of view of the subrogating insurers. So the first thing I heard, it puts us in more tension with our insured. That's what I've heard you say. Anything else, or is that the
Well,
limit of
yeah,
the
I mean,
problem?
that is the primary one. Is it puts us into more tension with our insured. It exposes us to defenses, equitable defenses.
Okay, and
that
what would
not
those be? That was my.
Oh,
I read
well,
that in your
you're
brief.
seeing an aversion of that, where they're trying to establish the made whole doctrine for the first time here, and that's not a thing that the defendants could ever do. The equities are never, the person who caused the injury never gets to say, your rights are less than ours. So ultimately, what happens here is the defendants get to make a deal. They get to have an agreement with the insureds, and then they get to stand up and say, we can't pay you more because it would hurt them. That's never a thing that they could do in a direct action, with us. That does put us in it. That prejudices our rights. And furthermore, go ahead. Furthermore, I think that this is sort of the way the question is phrased, where it says, can we release those subrogation rights, but then when they're preserved in the agreement? That's ultimately sort of this verbal jujitsu, right? It's impossible to release the claims and also preserve them. And if you read the defendants' briefs, they're very clear that we will no longer have the right to pursue them under and even though we did not agree to this settlement. That release is the thing that is our right that we are trying to pursue. If we can't pursue that anymore, if we are limited.
If we were to not adopt the make whole doctrine in the context of this reimbursement procedure, so I've heard two things now. It puts us more in tension with our insured, and they could assert the make whole doctrine. So if we were to not adopt the make whole doctrine, is there anything else, or is that what else is it about this process that would prejudice the position of your clients?
Sure. The other thing that we cite the Peters v. Weatherwax case, in our briefs, and one of the things that Peters v. Weatherwax, and I understand that there are different contexts for different kinds of subrogation, but Peters v. Weatherwax actually describes that in the event that this kind of settlement is allowed, where the insureds are allowed to release the subrogees right, the subrogating insurers right, that does create a sort of perverse incentive. What the quote from Peters v. Weatherwax was, it says defendants would be able to, quote, discharge their tort liability for less than what was just in the circumstances at someone else's expense. And that ultimately is really the core tenet of tort law is the person who does the wrong should bear the responsibility of it. And so the prejudice, and that's really the core premise of why subrogation was adopted in 1885.
I don't mean to interrupt, but while it's in my mind, I wanted to ask. But if there's a good faith evaluation by the circuit court, isn't that a protection against that kind of potential inequity, or kind of the risk of there being something collusive, or there being something other than a fair assessment of the merits of the case? Why not? Isn't that concern met by saying as the statute anticipates, the trial court needs to assess the validity of the claim of the lien, which I assume implies good faith?
Well, yes, so that is, so I think that where I would take some issue with that is usually when we talk about like a good faith proceeding. We're talking about it in the context of multiple defendants. It's, yes, this defendant can be released because they have given a good faith amount, and so it doesn't prejudice the rights of the other tortfeasors, the other defendants. I don't know that there is any case in any jurisdiction, I'm not aware of any, that has sort of a analogous good faith proceeding in which the insureds are permitted to release their insurer's right because it was in good faith and then force them into this proceeding. I don't know that there is
I'm trying to
any.
understand, but I'm asking you now repeatedly, what's wrong with this proceeding that is somehow prejudicial? And I just want to be sure I get it. One is it puts you in tension with your insured. That's your
Yes.
view. Another is they could assert the make whole doctrine, but if we don't adopt the make whole doctrine, that drops out. It provides perverse incentives to defendants, but the answer to that would be if the trial court has to engage in a good faith analysis, wouldn't that presumably protect against that?
Well, and what I'm saying is that there is no precedent for that good faith analysis. I'll give you the fourth one, which maybe I should have tagged it a little earlier.
Sure.
It puts us in the position of being the defendant's liability insurers because if they evaluated the case incorrectly, for example, now we don't have the right to pursue our own rights beyond what was previously negotiated without us being in the room, which that's an additional benefit that we were never paid a premium for. We're never contracted for. So that is prejudicial to us as parties because it changes the scope of our duties under the law.
I'm sorry, that's going, and I'm so sorry I couldn't hear part of your answer, but that's going to the notion that maybe they settled for an inadequate amount?
Yes, and that's similar to the Peters v. Weatherwax argument that we made earlier. It also reduces, and this was from Park, which we've already established is a very well-written decision, but Park describes that one of the reasons the subrogation exists is that's one of the reasons there's an incentive for insurance companies to undertake expensive investigations in the first place. And that's ultimately about holding the defendants accountable. And this is a wildfire. I don't know if the justices, if this court is aware of this. I mean, this is a very complex, specialized area of law. They're very expensive cases to litigate. It involves many different kinds of engineers, many different disciplines. And the only reason that these cases can be litigated this way is because of subrogation rights. Truly, and we expend tremendous resources in order to litigate these cases. And in the absence of that, those investigations would not happen.
Well, couldn't that be taken into account by the trial court in assessing the lien? This is our lien, and in connection with this lien, we incurred hundreds of millions of dollars in investigative costs. So we think that the lien should be adjusted for that reason, or the attorney's fees for the other folks who've been participating should be adjusted, and some should be given to us. Is that categorically impossible, or you don't think it's?
I don't think it's realistic. I don't think it's realistic to fashion a good faith proceeding for when one plaintiff can release another plaintiff's rights in good faith. I think that is hard to fashion what that rule would look like, and there is no equivalent rule in any other jurisdiction.
Yeah, again, I'm just trying to understand, that seems like a very legitimate point. Our insurers put millions of dollars into the investigation that helped advance this case. If that's accurate, that's an important contribution to the lawsuit by the subrogating insurers. But my question is, could that be taken into account in this lien reimbursement process?
I don't know how it could. I'd hesitate to prove the negative for a proceeding that has never happened in any jurisdiction, but I truly don't believe it could.
I understand your position to be that the legislature did not create a comprehensive scheme that covered property insurers here. Is that correct?
Or equitable subrogation at all.
The legislature did not affect equitable subrogation law.
I believe that is consistent with the language of Yukamoto.
Yeah. All right. If this court were to disagree, is it also your position that the legislature would not have the power to do that?
Again, I don't know what the power is, because every state has slightly different, we'll say boundaries of power for different branches, and I would be irresponsible of me to opine on that. I'm not a Hawaii constitutional scholar. I'm sorry. I do want, because I only have a few minutes left, I do want to get back into some of the made whole arguments briefly. Earlier, I started describing the importance of that limited fund determination, and there has been no limited fund determination at all. Ultimately, and what I mean by that is that this is actually the amount that that the parties can pay in order to that would necessitate making that we have to divvy up. You know, this is all there is. We have to divvy it up among people and start picking winners and losers. That there is no facts at all on this record to make that determination. That's really important for a made whole analysis, because limited fund is that way that we describe the core principle that the made whole doctrine applies only when there's a real conflict, you know, over a defined and finite pool of money that can never be enlarged. And that's consistent with the formulation in AIG v. Rutledge here, that there has to be an actual conflict between the insurers and the insured's recoveries before you have any discussion about what should be reduced and why. An artificially limited fund, which is what happened here, you know, it's not the same thing. There's an Ortiz v. Fiberboard case, you know, in the U.S. Supreme Court, which specifically addresses this. It says just because a mediator came down and said that this is the amount, and you know, this is the amount that I think that can make this happen, that is not sufficient for a limited fund finding. And specifically, it says in the context of mass torts, it was the fiberboard, because there's so many incentives for people to try to rush to get it done. You know, there's huge potential attorneys' fees issues, and there has to be a real fact finding of a limited fund, and that just hasn't happened here at all. And and this is one of the things that I think is important. We mentioned this in our brief, but when this number came down, you know, when the mediators gave it to us, there was no information at all about who was paying what. You know, today through December, 2024, the subrogating insurers have paid $2.6 billion. You know, it keeps going up every month. We're anticipating paying another $800 million before this is over. And ultimately, there was no way to evaluate, you know, what we were paying versus what the defendants were paying. You know, and here now we know today that HECO, you know, the primarily responsible utility that started the fire, is going to pay 1.99 or 1.9. It's significantly less than the insurers have paid. And one of the effects of this settlement, the way it's been trying to be portrayed, is that we, the subrogating insurers, will ultimately bear most of the responsibility. We will have to pay more than the people who actually caused the damage. And that is fundamentally inequitable. I don't think that that's really in dispute, or it can be disputed. Ultimately, we did not start the fire. We're the people who pay out monies immediately. You know, when claims start coming in, before we can even count, we start issuing checks, you know, trying to make people, you know, have some recourse when the worst happens. And that's the safety net that insurance provides. And ultimately what the settlement does is it kind of messes with the social agreement and the fabric that allows that safety net to occur. And that's a thing that I think that the court should be wary of, you know, in terms of its long-term implications. I mean, you indicated earlier, we've got to make a rule for not just this case, but going forward.
And I think one thing I want to ask you about, though, is, I mean, you know, you agree, we don't have those details in front of us. We're not asked to bless a settlement. We're asked 3 very specific legal questions to answer. And so, as the Chief Justice has mentioned several times, it would be for the trial court to, once we answer in whatever way we do, the legal questions, to work through a lot of the issues that you're now raising up to us, correct? And the question is what that process should be. Well, so whether that process should be under the statutes or otherwise.
So you're right that there are 3 very specific legal questions, and that's why the wording of the third one matters. You know, the third one says, I believe it's in the context of the Maui fire cases, you know, can the made whole doctrine be applied? And the answer is no. The answer is no, because that factual record doesn't exist. You know, as you're saying, it was rushed here. There was never any who can pay what. When the parties agreed to the purported global settlement, they didn't even know who was paying what. The reason, this is the truth, the reason that we rejected it is because it was impossible to evaluate the proposed settlement without knowing who was paying what and what amounts. It's impossible to advise a client as to whether something is a good settlement if you can't tell them who's paying what and over what time. And that's ultimately the reason that in the context to the specific legal question, you know, of these cases.
Wasn't that your choice, though, in a sense, because you filed your lawsuit here instead of in the Second Circuit, and therefore you weren't, but you did participate in the discussions, right?
So I'll push back on 2 parts about that. We filed our lawsuit in the First Circuit long before there was a mediation. We actually filed there because we thought that the docket would better able to support a mass tort case. It wasn't trying to avoid the other suits. It's just, it's limited judicial resources in Maui. And it was properly venued. I don't think anyone disagrees that it was properly venued in the First Circuit. It was possible to file in both locations. In terms of our participation, the reality is that we were never given any insight into what the number was. The mediator spent maybe 45 minutes with us total over 4 days. That's just the truth. And it was that they walked in and said, here is the number. We're not even going to tell you how much of the number you get. You have to figure that out. We will answer no questions. Come back to us in 2 weeks. And ultimately, that was not an acceptable proposal for large clients, large insurance companies that have to say, what does that mean for all future cases, for all future wildfire settlements? And ultimately, that's kind of what's happening here, is that the parties decided that we weren't allowed to say no, right? We weren't allowed to say no. Is that instead of saying no, then they get to agree with each other, collude in the terms of State Farm, that they will dictate what our rights are, the extent of those rights, if we don't agree to the settlement that's presented to us on a make it or leave it basis. So did we meaningfully participate? We were present. We were present, but we didn't really have a say in what happened. Does that answer your question?
Anything to wrap up?
Sure.
Mr. Romney, and you can go a little over the 45 if you need to make any
Sure.
additional points.
I think that the thing I want to end on is what Justice Ganoza started with early in the questioning, which is that this is not about just this one case. This is about all future mass torts. It's about all these other cases. And the law regarding subrogation in Hawaii has been stunningly consistent, not just across generations, but across even forms of government. Yukamoto emphasized consistency with Rutledge and Seoul. And, Kapena, which is a case from 1885, when during the Kingdom of Hawaii, said that subrogation is a rule which is founded on natural justice and recognized in every cultivated system of jurisprudence. It's a good rule. It's a good rule that exists everywhere, and there's no reason it should change just for this one settlement. Thank you.
Very well. Thank you for your argument. All right, Mr. Creed, your rebuttal.
Thank you. Thank you, Jesse Creed, for the individual action plaintiffs. I'd like to pick up where Chief Justice Rechtenwald brought up that the subrogating insurers were raising a good point about being reimbursed for their investigation costs. I think our position is that 663-10's language may actually allow for exactly that kind of process. The language is, and it's done day in and day out in the circuit courts, typically it's usually reimbursement of the plaintiff who brought the action, but the language is sufficiently broad to include any party who brought a civil action. And that language is, in determining the payment due to the lien holder, the court shall deduct from the payment a reasonable sum for the costs and fees incurred by the party who brought the civil action in tort. And I think that they brought a civil action in tort as well, and they could seek some compensation related to that to the extent that they would be allowed. I'd also want to pick up on the point, the question was asked, how do you really distinguish Yukamoto in the statutes for property insurers? And there was no textual basis provided. There's no textual basis that was identified in their brief. There was no textual basis provided by the subrogating insurers in their argument, because there is none. The terms equitable subrogation are nowhere found in the statutes. The term property insurer, or any section governing property insurers, is not cited or referenced in those statutes. There's no textual basis to do that. In addition, there was a discussion about the mediation process, and this is really about the initial mediation process. But the reality is that the plaintiffs and the subrogating insurers engaged in mediation as well over the division. And I know that's not in the record, but I just wanted to address that point. The subrogating insurers took no discovery in this case. That's something that is in the record. They've taken no discovery in the case as part of leading up to the settlement. I want to address a question that was brought up by Justice McKenna about the made whole doctrine and the special damages versus general damages. And so I think that the cases, I know we talked about the Rimes hearing, but if you look at this Washington Supreme Court case in Thuringer, there was also a evidentiary hearing that was done. And I think that kind of evidentiary hearing can also occur in the context of 663-10 to the extent that there are factual disputes on these issues. Special damages would also be, when you're determining duplication of special damages, if you have a person whose house cost $3 million to rebuild and they had $500,000 for insurance and $500,000 awarded under the settlement, there would be no duplication of damages in that case, and the insured should retain 100% of the recovery. In addition, when we're dealing with the validity of the liens, the insurance companies.
So are you arguing that there should be a difference between special damages and general damages in terms of the made-whole doctrine?
No, I think the made-whole doctrine should be evaluated in the context of the validity of the lien, which is from the statute. And the validity of the lien will depend on whether the plaintiff had been made whole for all losses, including general damages. That's the plaintiff's position. And that's why question number 3, it's still important to answer that. But even in the context of 663-10, and this goes to, I think, the real prejudice that the subrogating insurers care about is the prejudice that HMSA was also trying to avoid. They couldn't prove duplication of damages, and therefore they sought to circumvent the remedy provided by the legislature and sue directly the tortfeasor and extract leverage from that by obtaining a greater recovery than the remedy provided by the legislature. That is the tactical move that was done by HMSA, and also the tactical move that's being done by the subrogating insurers. And that's why, going to Justice Ganoza's point, or question, that's why no matter whether we're in the direct action or we're through 663-10, there needs to be a process. And the legislature has provided such a process through 663-10. Whenever there is a conflict between the insurers and the insured, and to resolve that conflict, there needs to be a process. The legislature has provided that process and subject to those standards. Thank you, Your Honors, very much for this opportunity.
Thank you, Mr. Creed, for your argument. And Ms. Andrews, pardon me, Andrews, your rebuttal.
Thank you, Your Honor. I just have 4 quick points. So first, the overarching purpose of this proceeding is for this court to consider whether to grant the finality that is necessary under the conditions precedent to this settlement to enable it to go into effect. And to obtain that finality, we would need a ruling that says that the lien procedure is the exclusive remedy for the insurers, and they may not assert direct subrogation actions against the defendants. And I would say that with respect to question 3 on made whole, we don't take a position on how the made whole doctrine might play out as between the plaintiffs and the insurers in the lien procedures. But I do think that questions about how that works could actually come up from a lien procedure in the context of a concrete case. So this court could actually look at that down the road after the parties have had a chance to address that in the first instance, and the circuit court has had a chance to address it in the first instance.
You're suggesting we simply decline to answer that question?
I think you could decline to answer that question now. And I would also say, just very quickly, that answering that question alone would not provide the finality necessary to enable the settlement to go into effect, because answering it yes wouldn't establish that the lien procedures are exclusive. The court could reformulate the question to also include the idea that the lien procedure is exclusive, but we would need to do that for the necessary finality. The second point I would make is that this court has construed the statutory text of the lien procedures to be exclusive. Unless there is some textual basis in the statute to exclude property insurers, that has to control here. That holding has to control, and we have not heard a single explanation all morning of the text that would justify not applying 663-10 to property. What I heard my friend on the other side say primarily is that perhaps you could say that 663 overrides contractual subrogation rights, but not equitable. There is no basis whatsoever for doing that. As Mr. Creed said, there's nothing in the text that does that. There's no substantive difference between equitable and contractual subrogation rights that would allow that. I see my time is up. Could I?
You can finish your thought.
Thank you. So the last thing I would say is that the settlement is structured to give the insurers everything to which they are entitled under existing Hawaii law. There is an overriding public interest in this settlement because it represents the wildfire victims' best opportunity to obtain compensation now to begin rebuilding their community. So I would urge the court to answer the reserved questions so as to reaffirm existing law and to provide the finality necessary to enable the settlement to go into effect.
Thank you, Ms. Andrews. Mahalo to all our attorneys for your arguments here today. The court will take this matter under advisement. We recognize the urgency of this matter and will issue a decision as soon as possible.
E ku iluna, please rise. Ua ho'o ku'u ia mai ne kea aha ho'o kolo ki I ke hano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.